get the questions, by the way. I sent it all last minute. I'm sure I forgot one as well. I'll have to apologise for missing someone because I've had questions coming from various ways this week.
I received them, but I'll be honest, and I haven't read them yet.
Yeah, I mean, yeah, it's cool. Hold on, let's mute that. Hey, right, everyone. Just bear me a sec. Usual back office stuff. Right, let me stick this in the chat. There's that, and I'll pin that in a minute. Because if it lets me, it does. And then what I need to do is go back here. Not even in the right place here. Sorry, getting there. And wait for it to load. Yeah, cool. All right. Yeah, welcome everyone. Hope you're having an all right week and you're getting some time off over the weekend in some way. Will's not here tonight, so it's just three. And I've got a few bits and notices and stuff, a bit of info to kind of go through before we get into the questions. But just the usual blurb. If you are asking, if you're asking questions, please anonymize them. So just ask them as what if questions. So what if someone was in temporary accommodation and X, Y, and Z happened? Rather than saying I'm in TA with my kids and they've got various disabilities and stuff and just kind of sharing their data everywhere. So avoid that if you can, that'd be awesome. And obviously this is not legal advice. We're going to do our best to give sensible answers, but it's not always possible. My voice might go. I've had a bit of an infection this week as well. My old glands behind my ears swell up. Never had that before, but hopefully I'm all right. So yeah, let's get into it. So first things first, right, a couple of sort of I guess just kind of like points of interest to say. Couple of interesting LGO decisions this week, which I've not had any time at all to actually digest. But if I just get the ones up, so this is Medway Council. Shannon, let me know if you can't see that because this is when I go blind. But so this is Medway, and it's I mean, basically it's a case where someone was placed in temporary accommodation and they were working for some of it. I mean, basically looking at the sums involved, there was kind of like, various kind of varying levels of wages and stuff like that. So you got, kind of the LGO going through like, how much this lady was getting here and here and all this kind of stuff. And effectively the council didn't ensure that the accommodation was affordable for them. There's like a template affordability assessment in their paperwork, which they didn't do. So she ends up I mean, I assume she got all the money she was owed in the end, but she also got about a grand or so, I think. Oh no, 750 quid. So she'd already got 250. I will probably do a whole video about this because it's just something which happens quite a lot actually. And although, I mean, it's kind of not, it's quite vanilla in one sense, it's so ordinary, but it's obviously affecting a lot of people. So that's that. This is when Zoom doesn't let me see everything. The next LJO thing actually came through this afternoon as well, separately from the usual things. And basically it's I mean, I'm hoping we're not seeing a trend here developing, but there was this, and before this kind of issue there was another one in Nottingham where essentially the ombudsman said the council had broken the law in multiple ways, and in Nottingham and now Hounslow's case they're essentially refusing to follow the LGO's recommendations. Again, I've not actually read the detail of this yet, but I don't think it's actually particularly complicated. They basically failed. I mean, we've got like a summary of the failings here, and they basically hadn't done it. I don't know if they paid a compensation at all, but anyway, I mean, I guess it can be tempting to kind of lose heart with all this stuff. But I guess if you're from, I mean, the only answer is people from Hounslow, which I don't know if we got any watching the live stream, but people from Hounslow need to go and basically share this link in their local We Are Hounslow Facebook group and kind of engage with the council, go to the next council meetings and saying this isn't acceptable, and basically hold them to account for it, because the LGO hasn't got any authority technically over councils. It has authority to kind of investigate, but it hasn't got authority to make councils follow the recommendations. So councils basically can ignore the recommendations, and at that point, the only thing you can do about it is just make it a public issue, which that is, I think, actually a very powerful one because councils obviously do care a lot about public opinion and so on. So if you're from Hounslow, or if you're in an area where you see this sort of thing where your council's failing to follow recommendations, you need to get very, very active politically with a small p. So it's not about being in a political party. That's generally a waste of time in my experience. But basically just making sure you're getting along to council meetings and you're just raising these issues, potentially sharing it with your local little kind of news outlets as well. So that was that. One of the regulars on the live stream shared this with me and Will this morning. So again, I mean, again, depressing again, isn't it? So I think it was how oh no, it's Hillingdon, I think this was. So basically looking at it, it looks like she's not in priority need. So she got a 19-year-old daughter who would not, kind of automatically be in priority need for that reason. And so yeah, so she's made a homes application, and in effect, I think really what's happening here is that Hillingdon are offering this property in Hartlepool as part of their relief duty, and essentially there's far less kind of requirement to ensure that accommodation is suitable when you're just kind of given these one of these kind of informal offers as opposed to a final accommodation offer or a well, in fact this could be a final accommodation I guess, but it certainly as a main duty it's kind of less it's less rigorous and effectively because because they are their age, they're not daughter's not at school or anything like that. There's very little kind of the kind of that's in guidance that would kind of tie them to Hillingdon. Although I think that I think the mum does work in Hillingdon or something. So yeah, so it's just I mean it's again it's just rather depressing. But I think this is a very ordinary kind of case again where some councils will just house people, in this case, nearly 300 miles away. And presumably have to kind of have this option of setting up an entirely new life where they don't see their friends anymore because it's way too expensive to be traveling 270 miles every time you want to go see them, or being homeless in the Hillingdon area and basically having a very bleak outlook, really. So, yeah, sorry, it's not been very, very encouraging yet. I think that's sort of bits I wanted to. That's the bits I picked up. Shannon or Karis, you got anything to you've noticed this week at all, or like things of note that you've seen at all? Let me sort my screen out here. Stop that share there for a second. And let me just do some more juggling. Yeah, so, oh, wow. Okay, so we've got a lot of questions coming in already. Let's get into it. So, yeah, unless you guys have got anything to say at this point, let's get into the actual questions. First one, let's get that up. So, okay, let's make that a bit bigger. So what if someone had been in temporary accommodation for 16 years? Council first accepted the homeless application when they were in a domestic violence shelter in 2009. A daughter, now 17, had been hospitalised twice on symptoms of serious bad health and continued to be seen by specialists and was medicated and having ongoing treatment for their health condition. Plus, the council had acknowledged that they cannot live in certain parts of the borough for safe reasons. They've basically been in an attack. I've kind of redacted some of this. However, despite this, and although the council are flouting their own housing allocation policy, the family were faced with going through bidding and competing with families that did not have the same restrictions as they did. So, as in like the geographical restrictions, I think that's referring to. Despite social services, local MPs and councillors reaching out to the council and providing them with supporting evidence from medical experts and family GP, they refused to raise the family's priority banding. Please advise they're desperate and their daughter's health is rapidly declining. They have emailed the council many, many times, creating their own policies and explaining why and how they are failing them, only to be told that the mother of the family didn't understand the policy. So, this is within the local government and social care ombudsman's remit, but to get to the LGSCO, you need to run it through the council's complaints process first. There's a video on the YouTube channel called "The Best Way to Make an Effective Complaint," which I would highly recommend, because I basically set out the laborious steps of actually making a decent complaint. One thing I would say is that one of the most important things about making a complaint is you make sure you are right. And if the policy is ambiguous or anything like that, you just need to make sure you've taken time to understand why they're saying the mother's understanding of the policy is incorrect. Otherwise, you can get into a situation where you go through all the way through the process. The LGO look at the policy and say, well, actually, the council hasn't broken it, so it won't be upheld. But I think that's, in one sense, that's the only thing I can see there is to actually raise it through that process. I don't. I mean, this is an interesting case because the duty was accepted in 2009. The council can only discharge this duty into the social housing. They can't discharge it into the private renter sector because that change in law came in like 2011. So yeah, I think that's the only thing they can do is to basically make sure their understanding of the policy is correct, make sure their understanding of the council's failure is correct, and then just crunch through the council's official complaints process. As I say, ideally by following the steps in the video. Things like making a subject access request early on is really important because you need to. It's the best way to kind of cut through the kind of the mess of the council situations that often get into, because you probably by this stage you're dealing with multiple officers who might have told you different things along the way. You just need to get it get the records so you can see what has actually been said when, what records there actually are, and really just kind of spend a bit of time. I mean, I would say that your councillors and MPs and social services should be in a position to really kind of help you understand that policy. And yeah, in one sense, if they agree that the council's not following its own policy, then it's disappointing they're not doing more. Hey, you're right, Michael. So yeah, I haven't got anything else to say about this one. Do you guys have anything to add to this one? No.
This is where if you did approach a solicitor, we could apply for a judicial review.
Okay. So that might not be a bad idea because I think I mean, I don't know if it says here. I'm pretty sure it's a London council. I don't know if it says it anywhere. But yeah, as in like, so London councils generally are harder to challenge than non-London councils. How's Virgo's capacity at the moment, Karis? I'm assuming, I mean, obviously you got the Easter weekend, but next week are you kind of looking like you got a bit of space?
Yeah, actually, we're
Okay.
looking pretty good.
Okay. So I
In-
basically, sorry, Shannon.
No, go on.
I was just going to say, so Virgos have got a Virgo or Virgos have got like a little like initial your kind of initial assessment form that the link to it is going to be on the description of the video once this becomes a recording. So YouTube, where it works is this is live stream. Once we finish, it then becomes a recording on the channel, and the link to the Virgos assessment form will be in there. Anyone can do it. It's like an initial screening tool to see if Virgos are likely to be able to help, and then one of the team will get in contact. So yeah, sorry, Shannon.
That's all right. I don't know if I'm just being slow today because it feels like it's been a long week. Um, what in this situation, Karis, what would you be judicially blah, 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 what would you be JRing, judicial reviewing?
Oh, we lost Karis. Is Karis frozen?
Oh, sorry. Hello?
So Shannon was just asking what. So in terms of a judicial review here, is it simply that the council's not following its own policy? Is it that simple?
Yeah, and they haven't done
Okay.
anything. And
Yeah.
it's
Okay.
inaction, really.
Yeah.
And that you've been given a non-priority decision.
Yeah. So I think so. It sounds like they're owed the main duty. It's just the issue is this policy may not or probably isn't being followed. So yeah. Cool. Right. Question two from just for those who haven't been here before. I initially go through the questions that have come in through the week, which are anonymized, which are my favorites because they aren't character limited and they are anonymized, which is also great. It saves me having to kind of mess around with them to get them in. And so this is question two. What if someone is given a non-priority decision and was told they're not vulnerable under medical grounds? Say if the person's homeless case has been closed due to the 56-day relief duty ending, they need to submit an appeal to the review officer to challenge a non-priority decision. Say if the person is signed off work on sick leave, are they able to get legal aid? How does the person write a good statement to win the appeal? Okay, so there's obviously several questions there, one of which I can answer. Um, I mean, I would argue at this point, most probably the way you're going to do this is you're going to there's probably going to be more information which was not included in the original decision, the Section 184 decision. And personally, I would say start the process again, make a fresh homeless application. And yeah, basically based on this new information. So as long as you provide new information that is more than trivial, which almost certainly will be, about the kind of the medical grounds, which again, because medical grounds, medical evidence tends to, kind of build up over time. There probably will be something new. So you've certainly got a choice, an option to trigger a fresh application. Again, on the channel, there's a video called "The Best Way to Make a Homeless Application," which I would again suggest you follow the steps methodically in that, because that's what I would do if I was homeless. Those are the steps I would take, and it is a little bit laborious, but it's worth the effort. So that's the first thing to say is that you could trigger a fresh application. You could do it under Section 202. You've got a 21-day time limit from getting the non-priority decision. But in my experience, it just makes it harder to then get housed basically whilst they make a decision, because this might be a bit too much of a tangent. If a cat, I mean, I think I did do a video. I've done a number of videos at the moment which I haven't yet published because there's some stuff that needs to happen before they're published. But I'm pretty sure I did a video about kind of sort of kind of no, maybe I haven't done it yet. But now basically medical advisors and kind of I'm sure I did something about like reasons to believe someone might be in priority need. So where inquiries are being undertaken, that there is a duty to house someone. If there are inquiries that need to be done, then for that period until the council's satisfied that the person isn't in priority need again, which may or may not take very long, there would be an initial duty to house them whilst that happens. Whereas it's a bit more complicated if you're asking to be housed under Section 202. The other thing to say is as well is I suggest probably again getting in contact with Virgos, because that's a sort of a bread and butter case, to be honest. And I'd be interested to hear stats from Virgos. I would imagine that the success rate of challenging non-priority decisions is very high, because councils are just so bad at them, and so they're so kind of perverse when they kind of consider medical evidence. So yeah, that's the first bit. Although yeah, this kind of touches on this thing about being on sick leave and whether you can claim legal aid. I mean, I'll leave it to Karis because yeah, she knows what she's talking about. But my guess is it's going to be based on your actual income, which if you're on sick leave, your income might have dropped, which means you might be eligible. But yeah, Karis, do you want to explain how that all works?
Yeah, can I just correct myself? I did read this as one question. So I was like, yeah, change it on priority need. But on the first one, I would talk about the Equality Act there and not taking in the accounts of the daughter. The second one, and legal aid, here you talk about judicial review. And legal aid is it's basically assessment on your income. So it depends on how many savings you have. If you've got assets such as a car, paintings or jewelry that could amount over to anything, or if you're in your own home, it's all based on your income and what assets you have. And if you're on sick leave, if you're signed off on sick, you can get statutory sick pay, which is a lower amount. Or you're in the process of applying for benefits. People on benefits most likely are just automatically attributed legal aid, but when you are working, we account to it, and it's how much of a disposable income you have. It's kind of what it's assessed on, if that all makes sense.
So is the best way in effect to approach Virgos and get you guys to do the assessment in terms of finances, and
Yeah,
which may at this point, so as I say, someone signed off sick, and maybe they're getting a lower amount of income, that might bring them back under the threshold to be able to get legal aid.
yeah, and we assess 1 month. So we would ask for your pay slips and your bank statements.
Yeah. Okay. Cool. And then in terms of how does the person write a good statement to win the appeal? Well, again, I think it's very straightforward for a solicitor to do it, because as I say, it's bread and butter. It's quite a different thing for a person who's never kind of come across the law before to make a good set of evidence. But crucially, I mean, I guess there's actually a playlist I put up this week on vulnerability, kind of putting together all the videos on the channel about it. Basically, there's two cases which make it much more straightforward to make your argument. There's the Smith v Haringey case, which is actually technically called Panio 2 v Waltham Forest, but it's the Smith element which is the useful bit. And then there's another case called Thomas v Lambeth, both of which there's stuff on the channel about. But they basically break down the test into 3 parts. So effectively, I mean, if we use the Thomas test as an example, what issues have you got? So here, medical issues they would be the issues. Would the results of those issues, as in the symptoms, be exacerbated by being homeless? The answer is almost certainly going to be yes, because there aren't many medical issues which aren't made worse by being homeless. And could there be some kind of harmful result which the healthy and robust person, to use the words of legislation, wouldn't have? That's kind of what it is. I've kind of mashed up the 2 tests there, but that's kind of the way to approach it. So you want to lay out your evidence in those 3 parts. So what are your issues? What are your medical issues? How are the consequences of those issues going to be made worse by being homeless, and what harm could result from it? That is going to be a very good case. But bear in mind, the issue often isn't actually the quality of the evidence you've got or the argument you're making. It's just simply that the council's perverse, which is why getting a solicitor is going to be actually a much more realistic way of doing it, because a lot of housing officers have never been trained on this anyway, and they're just under pressure to say no. And unfortunately, a lot of them just give in to that pressure rather than actually doing the right thing. So yeah. Anything else to say on that one, guys?
I would say with the council's decision, just assess what it says, and sometimes I think you said this before, Mike, it's a template letter, but go on when they've applied to what's relevant to you, and then talk about why it's wrong.
Yeah, cool. Yeah, because it's very common for those template letters to actually miss out loads of information anyway. and just kind of leave blanks in and stuff like that as well, which can make it a bit easier. But yeah, so I'd say first, yeah, on that one, first step, try and get a solicitor if you're eligible for legal aid. If not, see if there's any local charities that can advocate for you. But bearing in mind, most charities don't know anything about housing law, so that's a bit of a postcode lottery. So yeah, option 3 is to basically try and do it yourself. In which case, try to set out your information as Kara says. Basically, see if there's anything within the original decision which is obviously stupid, because there often will be, and then kind of just put your evidence into that kind of that format so that it makes it much harder for the council to dodge it. Number 3, what if someone challenged suitability of temporary accommodation in 1, but council want another suitability meeting in person, don't want to as have disability, and they say we'll go in person. Council seem to be looking for excuses. So councils probably will be looking for excuses. That's the way they work, a lot of them. But I think in terms of so basically, if the council's offered one property and then you successfully challenged the suitability of it, well done for a start. That's a good bit of work. But then the council's offering another property which may also be unsuitable. I think really you need to, unless it is your disability which is preventing you from going to that assessment, I don't think I don't think not going is really an option, or certainly it is an option, but it could easily result in some negative consequences and very negative consequences. So yeah, I think the kind of the issue is is it some is the wanting to not go as a result of the disability, or is it just because you don't trust the council to make a fair assessment, which is also equally valid but not a good reason not to go. So I think you need to look at it again. I'd probably say restate the disabilities you do have in writing to them and just basically say what reasonable adjustments you want the council to make. So it might be that they kind of do it at a particular time of day, or they potentially even help you with travel to go and view the property or whatever it might be. But I think not engaging with that process is likely to make it go worse for you. So I'd say if you just do whatever you can to get along to it, basically. And if there's a solid reason why you can't go, then basically state it very clearly. But yeah, as I say, I wouldn't recommend not engaging with it, because it just makes it gives them an excuse. Yeah, that's kind of the way it kind of works. So yeah, anything else you want to say? You guys want to say on that one at all? Because I think that's in fact that is the last one of the anonymized ones from the week, which is good. So we go up to the live chat now and see what questions we've got. I've seen we've got a big long one. So let's piece this together again. Just to say, guys, if you're putting a comment onto the video on the channel in advance, you don't have to put your messages over like multiple things. You can just put it as one thing. And basically, if you do it by like 6 p.m. on a Thursday, we'll have chance to kind of get it in advance. What is that? Because it just makes it very difficult here for me to figure out what's going on, if nothing else. And so you have to watch me struggle with technology as well. Here we go. I think I'm getting there. Okay, then there's further. I don't know if this is related, but I'm just sorry, guys. I'm trying to figure all this out. Yeah, okay. So let's have a look at this. So Section 21 notice was served to a family with dependent children, and the notice expired 4 months ago. After the expiry of the notice, the housing officer closed the family's homelessness application despite being aware of the landlord's intention to seek a possession order. In the meantime, the court's possession order claim was received a few weeks ago and forwarded to the council. They then reopened the application under prevention duty. Okay, they should be under relief duty for a start. The family requested a review of this decision, which may again be about the relief rather than prevention. The previous housing officer who had closed the application has now been reassigned to the case. At this stage, is the council right to accept prevention duty when the Section 21 notice has already expired? So yeah, I mean, the guidance kind of falls short of kind of giving a nice, easy answer, but the answer is it's very unlikely that you're not homeless at this point in time. This person's not homeless. So I mean, again, I will just bring up and I know we kind of probably look at this every other week, really, but it's such an important one. It is worth kind of looking at it. So if I just stop sharing there and go into the code of guidance. So it's all basic. I mean, yeah, we're not going to go into full detail. There's a video on the channel, by the way, which is like if you search for the term bailiff, you'll find it because I basically lay it out there and I also give some LGO decisions. But effectively, so 6.35 is basically saying that in most cases you're going to be homeless, therefore owed the relief duty the day after the Section 21 expires, provided that it's valid and provided that the landlord is serious about seeking possession, which obviously in the question here, the answer is yes, they are. So then it says the Secretary of State considers it as highly unlikely to be reasonable for the applicant to continue to occupy, which is a code for being homeless, beyond the date on which the court has ordered them to leave the property and give possession to the landlord. But as I say, by this stage, we're kind of probably already talking about someone who's already homeless. So yeah, I mean, um, we're talking here about a person who's going to be in priority needs. Sounds like there's no indication that they're intentionally homeless. So in one sense, there's not a lot to lose by making a complaint at this stage. Sometimes we kind of say, actually, because the fact you might get some retaliatory action from a council if you complain, sometimes it's better to kind of try and prevent or delay making a complaint until as late as possible. But here we've got a situation where, yeah, it's pretty obvious the council's likely to have broken the law here. So personally, again, I would go back through the usual process. So again, video on the channel, best way to make an effective complaint, follow those steps, and just run it through the complaint process. That is probably the most effective way to get the council to wake up to actually deal with it. Because in effect, there is a duty to provide interim accommodation to this family, and there's a good reason why that's there, is because if the family do stay much longer, they're going to be risking paying court fees and stuff like that, which if they complain, it's likely they're going to get them back from the council when the LGO investigates and upholds it. But yeah, so yeah, search for the term bailiff on the YouTube channel as well. In the description of that video, there's two cases which basically give both sides of it, because the tenant can get compensation, but the landlord can also get compensation if a council tells you to stay until the bailiff comes, or basically tells you to stay longer than you should be. So yeah, and it is, I mean, I would say it's worth doing it. I mean, the difference is going to be is that, first of all, your effective registration date is going to be earlier if you do this. And also, you're going to get offered interim accommodation earlier, which you can still turn down. You can still say, no, I want to stay till the bailiff comes, but there aren't many good reasons to, well, there aren't many good reasons to do that. So, and then can a family request a case be assigned to a different housing officer? Probably not. I mean, probably not. We can ask, but really, it's probably not even that this particular individual housing officer's fault. It's probably the council's policy itself. The frontline officers are being told to take this line, and again, they have a contract to follow the law, but many a lot of the time they don't. But I don't think changing the housing officer is going to result in a better case. I think you just need to run it through the complaints process robustly, and I think that's going to be the way to get a good outcome there, or a better, good outcome as possible. So yeah, anything to add on that one, guys? I think I've answered all the bits of it. Yeah, but yeah, basically, long story short, sounds like this person is actually owed the relief duty rather than the prevention duty, and also maybe owed the interim accommodation duty under Section 188. So yeah, my next question, which I don't know the answer to, but we'll have a go at it anyway. So someone I know very well was sent a £90,000 bill for housing benefit overpayment and had their earnings garnished. Garnished, does that mean like kind of earnings, like the thing where there's like a compulsory kind of like non-voluntary thing where the earnings just go straight to the council to repay it or something? I don't know what that means.
I thought it meant like embellished.
That's yeah. Maybe the person doesn't mean garnished.
You mean
Tarnished.
like seizing money?
Yeah. Is that what it means? Is that what garnish is a food thing, isn't it? I don't know. But yeah. So okay. What's the actual? Unless you, what's the actual question here? Is that legal? So there's a bit more. Okay. So the family can't get
They've
legal
just
aid.
put attachment of earnings.
Right. Okay. So yeah, is that basically just they subtract it straight off the? So yeah, I mean, I don't know a lot about it, but I think the best you can do is basically apply for the repayment levels to be minimized. I mean, and to be honest, no, this is one to go to get good financial debt advice, because and don't quote me here, but this seems to be the sort of situation where I just think about going like just declaring bankruptcy. I don't know if a debt to housing benefit is actually something which would be wiped off if you were, but essentially you want to get some expert financial advice here from a local service to basically see what you're going to do about that, because it gets really messy actually, because what it might actually mean with those reductions or with the kind of deductions, it might actually make the person homeless through unaffordability, because effectively, going back to this idea that you're homeless if you can't afford your rent. If you're getting if you're getting any level of reductions off your income, it might actually make you homeless anyway. But I mean, 90K. I mean, I don't know. It seems like the sort of case where the housing benefit team in the council would know the case very well, and probably other council officers as well. So yeah, I think my answer for the time being is going to be go and get debt advice, see what they say, and then potentially, if you are essentially, which someone probably would be in this situation, probably not able to kind of make ends meet because of the deductions, it might be a case of making a homeless application based on unaffordability. And weirdly, the council would have to take that seriously, even though it's the housing benefit department that's taking money off. It might then effectively be the housing options team who are then, just get a discretionary housing payment or something for you to actually top it back up again. It seems to me like a situation which needs some intelligent people kind of in the council to actually look at, because it's just throwing a millstone around someone's neck really, just to kind of give them that sort of level of debt for probably the rest of their life. So yeah, anything else you want to add to that at all? So they just asked, can we help? So if you can't get legal aid, not easily, no. I mean, other than kind of, I mean, to be honest anyway, it's the sort of thing you probably want to get debt advice. And it's going to be debt advice to go to rather than housing stuff initially, to see what the actual position is and see what options there might be. Because I mean, obviously it's an absolute last resort to declare bankruptcy, but £90,000, I don't know, that might be something which is kind of actually makes sense in the situation. So yeah.
And also, I would just, that's not housing, sorry.
Yeah. Cool. So let me just check I've not missed anything. Okay. So next one I can see is when having a housing assessment by phone, are the calls recorded? If a person mentioned important information, it was omitted by the assessor apart from an FOI. How can a person obtain info? So a lot of council calls are recorded, but and in theory they are discoverable by making a subject access request. But I suspect that a lot of the time, as soon as you request it, the council say, oh, we delete the calls after like, 1 day or whatever it is. So you can certainly try to. I think the question would be is like, what's the important information that's been omitted? What's the issue? And initially just try and kind of write to the council. It might be just a case of writing to the assessor and saying, look, you've actually got this wrong. You missed a bit of information out, whatever, rather than sort of jumping in and saying, I'm going to prove that this council officer has messed up. You might initially just start by saying, look, you've just got a little bit wrong there. Can you just correct the records? And if they then say no, that's not what was said, or whatever it is, then maybe then do a subject access request to get a copy of the recording. I don't know if this is just for me. If I was ever homeless in this situation, I would record covertly every conversation I ever had with the council, for this reason really. It's legal. You can do it. It's been called distasteful by judges, but you are legally allowed to do that. And as I say, if I was homeless, speaking for myself only, I would be recording everything, basically, because this sort of thing happens a lot. But I think my kind of first answer would be see if you can resolve it kind of gently and just kind of say, look, you just missed a bit off there, or you misconstrued what I said or misunderstood what I said, rather than kind of going in and saying they're lying and kind of make an issue of it. So yeah, anything to add on that one, guys? If not, we will go to this one here. A person was informed that the council requested 2 weeks ago 2-week extension for any decision review under Section 202. Will a decision be made exactly on the date, or could it be earlier? Thank you. So, it certainly could be made earlier, but most likely there might be another extension after the end of it. That sort of thing wouldn't be unusual either. So I think if the person's in temporary accommodation whilst it's all happening, that gives the council an incentive to do it as soon as possible because they're paying for TA and they're going to try and say that there's not a duty. So, but yeah, I mean, I'm not sure if we can give a kind of a any sort of answer for that really. The answer is it could do, or it could take longer. It could take the actual date. The way a lot of councils are at the moment is they're just kind of rolling over reviews again and again and again, which can make it very difficult if you're in that sort of limbo, particularly if there's probably a duty to house you, but the council is denying it. So that's one of the advantages of triggering a fresh application where you can rather than doing Section 202. Because if you trigger a fresh application, in effect, it's easier to trigger the duty to be accommodated if you've got new information to do so. So there's a comment there which I'm not quite sure which question it relates to. So in an AST for 16 years, I think is that the temporary accommodation one maybe? But that's so temporary accommodation would be an AST. It'd be, I mean, well, no, you can't be an AST. An AST. It's going to be some sort of license agreement. Although in London, it's not unusual for people to be in TA for like 10 or 20 years in some cases. So yeah, done that one. So some interesting stuff here. Okay, my screen's just jumped. I've got to go and find my place again. Hold on. So we've done that one. Okay, so I think this is the next question. I'm trying not to miss anything here, guys. So, oh, that's now done it in white text for some reason. Awesome. Under relief duty, can an applicant refuse a private rented accommodation if the person doesn't receive formal offer for a property? I mean, yeah, if there's no, if there's no kind of like nothing in writing, I mean, in effect, if the council offers you a property, then you refuse it. If the council is then going to try and end their duty, they need to have shown that they told the person what the consequences were. I'm pretty sure it says in writing. So on the channel, there's a video which is called "Can I Refuse an Offer of Accommodation" or something like that. So if you search for the word "refuse" on the YouTube channel, you'll get a video which I talk exactly about this, and it gets quite complicated. So I did it like a year ago, so I can't exactly remember what I said in terms of like the bits of the guidance, but I basically based it on the guidance. So yeah, I think I mean, I think the really confusing thing with the relief duty is there's two formal offers. There's a final accommodation offer or a final Part 6 offer, and then there's this kind of like something which I call the informal offer because it's not actually given a name, which is basically an offer of accommodation which is likely to be available for 6 months, but it falls short of an assured short hold tenancy, which would be in a final accommodation offer. So basically there are various consequences of refusing certain types of offers, but if it's not actually a formal offer, then you get a lot more leeway. So let's say you're in priority needs, you're not intentionally homeless and you refuse an informal offer, then the council will basically proceed with, they might end the relief duty, they'll issue a final decision, which is that they're going to owe you the final accommodation offer anyway. So it's all ridiculously convoluted, but have a look at that video on the channel. Just search for that term refuse. You'll see the video and have a little look at it because I think it probably answers it better than I can here right now. But yes, I mean, I guess whenever you are refusing an offer of accommodation, you need to make absolutely sure you know what you're doing because you're much safer to accept the accommodation and then ask for a review of it. But then this gets complicated because you might just get a rubbish offer of accommodation, which you can't even not review it because it's not even a formal offer. So yeah, watch the video, I think is my answer. I kind of, as I say, I'll focus in on the detail you need to know to actually make that decision and work out what you're doing. But yeah, don't do it carefully. Don't take that one lightly. Don't refuse off accommodation ever lightly unless you know what you're doing. Yeah, it's just a number of comments coming in here which are all helpful. I'm not going to read them all out. So yeah, just someone making the point that it's very, very difficult to challenge the suitability of interim accommodation. You basically need a lawyer. You can't really do it without a lawyer, in effect. I mean, you can complain about stuff, but without a solicitor to judicially review it, you're going to struggle. So I think this goes back to the question. Hold on, this one back up here, actually, question 6. So let's put a full stop there. So if told that calls made via Microsoft Teams, the council's main telephony and communication systems are not audio recorded, and therefore is not possible to provide transcripts of call. Is this true? So with Teams, I hate Teams, so I avoid it at all costs. I generally use Zoom, but in my experience of those video conferencing calls, they will say if they've been recorded, like you'll get a notification saying this has been recorded. So potentially, yes. So potentially, if it was all done on Teams and you weren't notified it was being recorded, I would say the chances are it wasn't. That's probably going to be my guess. Whereas when you're on the official phone system, it will kind of tell you before you pick up or whatever. These calls might be recorded for training or monitoring purposes, which means that they may well be available to actually get from a SAR. Shannon?
Yeah, but you can also put on a transcript without recording it. So that's the same as Zoom and Teams. You can have a transcript of the conversation without recording it, and I think it doesn't necessarily tell you if there's a transcript going because the transcript's for you on your device. I think it should do, but I don't know off the top of my head. But yeah, so you would be able to get a transcript from a Teams call without it being recorded. It's not impossible.
Okay, cool. Question 9. When should your housing officer determine if you're in priority needs? Before or after the 56 days of relief duty? So good question. The council need to pretty much immediately determine whether there is reason to believe you might be in priority need when you first make the application. Because if you might be homeless, might be eligible, might be in priority need, they owe you the Section 188 duty. And if they then proceed to make inquiries and they satisfy themselves that you're not in priority need, they can issue that decision within the 56-day period because they'll want to end the interim accommodation duty as soon as possible to save themselves money. So a non-priority decision can be given within the 56-day period, but in effect, councils are told they shouldn't accept the main housing duty until the 56 days has passed. So basically, if you read the code of guidance, it basically says council should make the main duty decision on day 57 after the relief duty starting. There's a lot of detail in what I just said there. Actually, a lot of kind of caveats with that. But so that's really it. So they'll be making inquiries into priority need in the 56-day period, and a good housing officer will say, look, it looks likely that you're going to be in priority need because that's going to put your mind at ease a little bit. But equally, the whole game of the relief period and these kind of offers of accommodation in the relief period, they can't. I don't know if it's fair to say that the legislation has been designed to make them as unappealing as possible, as in to put you in a position where you want to take these relief duty offers rather than wait for the main duty. So that's kind of the way the law's been formed. So yeah, it's entirely possible that what I'd say is simple answer is you shouldn't get a positive priority need decision within the 56-day periods, but you can get a negative one. Hopefully that makes sense. Ridiculous, isn't it? But yeah, that's I think that's the answer. So just someone saying the landlord can't claim cash from the local authority for waiting until eviction. They can. So there's been LGO decisions uphold. Yeah, they do it. So I can't remember if it's Islington or Brentwood, but basically, if you search that video on the channel, the bailiff one, there's a couple of links in the description, LGO decisions, and so there's one where the tenant gets like £7,000 or something, which is quite unusual because there's some circumstances which are unusual. But then there's another one where the landlord got the money, basically got like £1,200 or something, and that was simply because the council told the tenant to stay put, basically, and the landlord got compensation for that. So yeah, it's one of those things where I don't really know why it's such widespread practice. My guess is just not enough people challenge it. Right, what's my computer doing?
I'm sorry, should I just say it? They will tell you as soon as there's reason to believe that you may qualify, isn't it, for the priority need?
They'll make that initial assessment whether you might be in priority need at the beginning of that process, or in fact technically before the relief duty starts. But obviously a lot can happen in that relief period because it might genuinely be that there's no reason to believe when the person makes the application, but then further down the line there is reason to believe, at which point the Section 188 would kick back in again, so or kick in for the first time. So there's lots of things that can happen the way that kind of works. So yeah. So again, it's probably not, it's more of a benefits question than a housing question, but we'll see what we can do here. So what impact will working do if you're on housing benefit and start working? Would they stop your housing benefit? And how does working affect your chance of getting social housing if you're in TA? So it's all going to depend on your like how what you're earning, because it basically tapers off. Can be for universal credit, it can be really good to kind of hit that sweet spot of like 16 hours or whatever, or roundabouts. So yeah, you need to do a calculation. If you go to like, was it Turn to Us or something, you can go on that website and just kind of just put in your details, and you'll get a sort of an estimate of what you'd get. In terms of how would it affect your chance of getting social housing, so I don't think there'll be. Oh, I'm trying to think. Every council's got a different policy when it comes to social housing. It won't have any bearing on main duties directly, but there is a kind of basically there is a chance that it might reduce your chance of getting social housing, because depending what you're earning, that might, if you're earning a significant amount, if you're earning more than you would, if you weren't getting, if you weren't in employment, which you probably will be, then that basically makes private rented accommodation more affordable for you, and therefore, councils which have only got limited options, they will look to match people up who can afford more into the private rented sector. So it's a bit like couples without children; they're much more likely to get private rented than social housing, just because they can afford more, because they've got two income streams, but only have to do utilities once and so on. So they effectively have more money available. And so again, they're more likely to get private rented. So that's all I can probably say about that. So, but that may not be for every council, but certainly the council I've had dealings with, that might be a factor. Equally, although some housing allocation policies favour people in work to some level, I can't remember how that works because there was a big discrimination claim about that. I don't think if you owed the main duty, you're going to get a set banning anyway. I don't see being in work is going to change that really. So yeah, that's I think that's the answer on that one. Cool. Right. Probably how are we getting on for time? So I'm probably going to put a just a kind of time limit on no new questions from this point. So any new questions, just roll over to the next one, as in like ask them again and put them on the channel or whatever. So yeah, where are we going up to? Okay, wasn't just a nice bit of feedback there. Oh, nice. I think that's good news. Sounds like there's still some stuff going on there, but just someone saying that kind of they're getting a good result with the council, which is cool. Good to hear. So yeah, okay. Next question, I think I can see. Someone in relief duty, 56 days past months ago, homeless prevention officer haven't responded or doesn't. The people urgently need social housing, 2-bedroom apartment. So, I mean, yeah, I mean, you're kind of probably jumping too far ahead here. Where at this stage, if the relief duty, if basically the council haven't made a final decision yet, which sounds like they haven't, your first kind of thing is to basically show that you're in priority need, you're not intentionally homeless and so on, so that they owe you the main duty. And then once you owe the main duty, that in no way guarantees you getting social housing. As we saw in that report from wherever it was in Hillingdon, people who effectively weren't in priority need were basically pushed up to Hartlepool in private rented, and there will be plenty of people who are in priority needs who will also be pushed up to Hartlepool in private rented, who are owed the main duty. So yeah, I mean, bearing in mind you're going to be a name on a list of 1,000 people who are waiting for a 2-bed and are waiting many years for it. So yeah, and many of those people will have also equally urgent kind of issues going on. So you can't, I mean, in one sense, as I say, focus on getting the council to issue a decision now. I think obviously ideally that they owe you the main duty. It may well be kind of worth complaining. It just depends on the strength of your kind of, as I say, kind of comes back to this idea that if it's not clear cut and you complain, some housing officers will then basically take that out on you, and they'll just issue a non-priority decision anyway. So chase it politely initially and then kind of go from there. I mean, the LJ will basically pay a couple of £100 to people where they have been left in that limbo. but that doesn't necessarily get you housed or anything like that. So yeah, difficult to kind of say without kind of knowing the ins and outs of the case, but I'd say chase the council gently initially. If you don't get anywhere, chase them more a bit more robustly with a complaint. But yeah, the need for 2-bed social housing, like, yeah, unless you live in like kind of Bassett Law or something, there's very little chance of you getting 2-bed social housing anytime soon. If ever, you might just get private rented offer at the end of it anyway. So I'm just saying that, so it can be a short tenancy under TA. Okay. Yeah, I mean, I don't know how that kind of works in terms of when it's surely it's just a bit messy when people then move on, but yeah, I think there's just a bit more questions out on there. So I'm just kind of piecing through any more questions here. So someone is saying you do get higher banding with employment, but I haven't seen a policy where if you already owed the main duty, you would get additional priority for being in employment. I've never seen it, but I'd be interested to hear if there are particular councils which have that policy. As I say, I wasn't following at the time, but I think there was a big case when a lot of councils after 2011 they tried to kind of put this thing on saying that if you're working you're going to get more priority, but then clearly that's going to discriminate against people who have got disabilities and can't work. So I think there was a case about it anyway. So yeah. Stockport, okay, yeah, cool. So I might have a little nose around that policy, just see how that works and kind of how much additional priority you'd get. Okay, so there is one more question from the week that wasn't anonymized, which is this one here. And there's actually another one about a veteran actually, which I haven't got around to yet, so I'll do that in a moment as well. So yeah, and just to say, guys, I feel like I've missed someone's question. That someone asked me a question somewhere along the line, and I have missed it somewhere. So I apologise if that's you. Do get on the comments on the video and try and chase me for it or whatever. I'll try and do something about that. So hi there. I needed some advice. So me and my child are in interim accommodation. I've been told by the housing officer that I will be found intentionally homeless, and that they cannot help with a bond either due to me being found intentionally homeless. I don't know what to do. Okay, so it's you need to challenge the intentional homeless decision ASAP. So you've got 21 days from receiving that decision to challenge it. And it may be you don't have time to kind of put a fully formed argument together, but just send something saying I'm arguing this, and then kind of lay out your reasoning for it. It's very difficult to be intentionally homeless. Like if you are genuinely intentionally homeless, you'll know about it because it means you genuinely did do something which obviously was going to lead you to be homeless. If you look, I mean, I'll kind of just flash a few bits in the code of guidance you may want to have a look at, which will often act as defenses against intentionality. So if we go to 9.7 first, and then 9.17. So basically, this is the definition of intentional homelessness laid out here in the Code of Guidance, but it's from section 191 of the Housing Act 96. And the key thing for this is that all three of these have to apply. And you'll often have situations where arguably the first one does apply, and maybe the second one as well, but the third one doesn't, because this idea of reasonable to continue to occupy is really key. That's that code for being homeless. You are homeless if you have accommodation, but it's unreasonable to continue to occupy, and that could be for a number of issues, including affordability, like severe disrepair, abuse, risk of abuse, unsuitability for medical issues, that sort of thing, severe overcrowding, that sort of thing. So in one sense, if your accommodation was not reasonable to continue to occupy, it doesn't matter what you did here, because all three have to apply. So you might have, flippantly say, you might have punched your landlord in the face here and quite rightly deserve to be evicted, but that does not automatically mean you're going to be intentionally homeless, because this might kick in here. And then if we go down to 9.17, it kind of expands on that first one there. So, this idea of, deliberately doing something or not doing something, which would generally be committing antisocial behavior, committing a crime, not paying the rent, abandoning it, subletting it, something like that. So if you go to 9.17, you've got a couple of things here. So first of all, it kind of touches again on kind of, benefit delays, income issues, that sort of thing. You've then got these two things here which talk about someone's basically not able to manage things because of their mental health or substance use issues, where mental capacity is in question, and then you've got this one here, which would also include potentially where people are getting exploited or cuckooed or whatever. So yeah, so that's your first kind of line of line of defense is going to be to put a section 202 request in, and again just kind of also just digest the contents of the section 184 and see if you agree with it, because you'll often get, I mean, sometimes you get wacky stuff. I mean, I have talked about it before on the channel. I remember when probably the easiest complaint I ever got upheld with compensation was a survivor of domestic abuse, where the first entry in the council's log was, homeless applicant is at a considerable risk of abuse. I told her if she left her home, she'd be intentionally homeless. Some officers are really that thick that they'll say stuff like that. So you just need to check out that. Again, this would be one for a solicitor. So again, look at Virgo's, have a go at the initial assessment form to see what can be done. But there is this kind of real kind of time dynamic here, because whereas with a non-priority decision you can often kind of get more information to trigger a fresh application, it's much more difficult to do that with intentional homelessness. It's possible, but it's not not as straightforward. And then if that fails, you've got a couple of options. Basically, the housing team should ask for your consent to share your details and refer you to children's services, who, I mean, basically they can't allow children to be on the street, and they can't remove children from a parent's care for want of housing. So that is, kind of an absolute safety net, but that is rough. There's no kind of quality standard in terms of suitability with that, really. It can be anywhere in the country. In fact, a lot of councils will just house you as far away as possible just to boot you over the parish boundary, so then you're not their problem anymore. But the other thing you could do is you could, again, it's not potentially like a longer term thing, but you can make an application to a different council. You don't need local connection to make an application, although lots of councils, really kind of act unlawfully around that. But it's entirely possible to have more than one local connection. So although you can approach anywhere without a local connection, it's if let's say you've been living in one area, but you've got parents who live in another area, and you've been found intentionally by the first council, you can go to the second council and make an application there. That, in the very least, will give you 3 months or so in temporary accommodation, which again, not ideal, but it's kind of like it's going to give you a bit of time to figure out what's going on. But I'd say plan A is to successfully challenge the intentional decision. Plan B is probably to make an application to a different council. Plan C is kind of fall onto the support that children's services offer. That's, as I say, that's a rough process. That probably involves you camping out in the local social services reception area with your suitcases and refuse to leave. And at 7 o'clock at night, they'll finally get around to it. So yeah, but yeah, I've only worked with a couple. I can only think of a small number of people I work with who are actually intentionally homeless. Because even when they went to, people are committing crimes and going to prison. As I say, when you actually look at the details, look at the circumstances they were living in, actually you could show that it was not reasonable to continue to occupy the accommodation anyway. So they're not intentionally homeless. So yeah. Yeah, cool. Okay, I think that's it. No, oh yeah, the final question. Sorry, there was one about veteran, which I wanted to talk about. So I've hold on a sec. Effectively, I've completely redacted this because there's quite a lot of information in the initial referral. But basically, there's the situation here. The guy is a veteran of the British Armed Forces, which is a potential priority characteristic, but it's not automatic. So being a veteran in itself doesn't make you in priority need. You need to show that you're vulnerable as a result of it. Now, the support worker involved in this individual's case basically says there's definitely evidence of trauma, significant trauma, but the individual's not accessing help from a GP or whatever. That makes the job harder. And I guess probably plan A again is to try and get the guy to go and see his GP to kind of get some updated diagnoses and stuff. But there would potentially be information which would also be relevant. So, for example, you could actually go back to the individual and say, look, talk us through your experience of being in the forces. How did it affect you? I always kind of say, wherever appropriate, to go back further and ask people what their experiences of life were before they went into the forces, because you have a lot of people who are in institutional backgrounds before they go in, which will obviously be relevant as well. So you might be able to get information from his former regiment. in this case, this guy had basically stayed at a veterans hostel as well, and again, the hostel might have access to information which would be relevant. But again, you need to put your argument together in terms of the Smith or Thomas test, which is, identify the issues, which in this case, in the very least, is going to be a veteran with trauma. Talk about, how the consequences of those issues will be exacerbated by being homeless. So if it's trauma, kind of trauma is not a specific diagnosis, but bear in mind, and again, it's kind of easy to get caught up in this. It's easy to get caught up then there needs to be a diagnosis to evidence medical vulnerability, but there doesn't. You're going on the presentation. So you don't have to have a diagnosis, although it's going to make things a lot smoother. It's a little bit like you don't have to have a police crime reference number to evidence domestic abuse, but it's better if you do. So yeah, kind of lay that stuff out, and again, just kind of focus on what harm is likely to result from, for this person compared to a healthy and robust person who was not a veteran, who was not traumatized, and kind of show that there's some kind of noticeable difference. Again, I've kind of amalgamated both tests there together, but yeah, and just yes, and so British Legion being mentioned now. I had some good experiences with SAFA, not recently, just because I've not had dealings with them, but certainly they were good. Not magic, but good. So get them involved if they're not already. I think for both of those charities, you get eligibility if you've served in the forces for a day or more, or something like that. So it's, the person we're talking about here definitely would be. And just kind of like, again, politically. So the mention of the Armed Forces Covenant in the chat there. I don't the Armed Forces Covenant is kind of like well, I think it is optional, but a lot of councils sign up to it. Again, I don't know what direct bearing it has to priority need tests, but clearly politically, councillors don't like to see veterans being left without support. So the engagement with councillors is obviously going to be useful as well. Yeah.
And
So,
also sorry, can I just point out the lack of engagement or difficulty engaging with professionals? That's part of the trauma, that's part of a disability, that's part of mental health. So this should be treated as such, not something of, oh, they're difficult and they won't engage. So if you knock on the door and they don't engage with you, then they're training and they should be it's on the services to engage with them, not on the person trying to deal with the professionals. Professionals should be professional.
Yeah. I mean, not that it was mentioned in this case, but there is a strong correlation between trauma and substance use. So again, substance use might be something which is relevant around priority need as well here, depending on the fact, depending on what's going on. But yeah, I mean, I agree with what you say, Karis, 100%. I just think to get a cynical housing officer to see it that way is a challenge. Yeah, if ever there was one, really. So.
And that's where the Equality Act comes in, reasonable adjustments, and then you put all that for disability, reasonable adjustments.
Yeah. And on that note as well, I guess, maybe doing some work with this guy as well about making sure he's claimed the relevant benefits.
Yeah.
If he's eligible for PIP, that sort of thing, that's going to help. So. Yeah, I mean, so someone just say most local authorities now recognise trauma and multiple disadvantage. They might not in the real world. They don't. They've done a headline people might do, but the housing officers will absolutely re-traumatise and in fact traumatise people for the first time, in my experience. So I don't. Yeah, I have not seen that on the ground.
Yeah, I think that's an accurate comment. Most local authorities recognise trauma and multiple disadvantage, but they do not work in a trauma-informed or holistic approach at all, in my opinion, my experiences and stuff. And I think that kind of makes it worse. That, as a sector and as like a country where, and in other sectors are brilliant when you've got someone who's, approaching with trauma and lots of different things going on. And I think it would be amazing. It would make such a difference if housing officers could sort of react and respond to individuals in that way. But unfortunately, I don't think it's what we see each week in and out. And I think until local authorities start listening to people with lived experience, their services are never going to be that trauma informed haven that we'd love it to be, unless they're doing co-production.
Yeah, I think it's operating on a couple of levels here. It reminds me of Yemshaw v Hounslow case, which was like a 2012 case about domestic abuse, and it was basically the case which shifted domestic violence to being domestic abuse. So it's, you know, not just about being hit. And in that case, it was interesting because the judge quoted Hounslow's own advice leaflet, which was in the customer service centre of the council that the homeless Miss Yemshaw was going to, which basically said, you know, it's an escalating pattern of abuse, it's kind of coercion, you know, all that kind of sort of non-violent, non-physical violence stuff. And that was a situation where, yeah, the leaflets and the kind of the material available from the council was like, you know, right, and yet the realities of housing officers on the front line. I mean, you know, the person who's not agreeing with us here is from Stockport. Maybe Stockport's like an absolute, you know, doing an absolute blast. I've worked with dozens and dozens of councils. Yeah, my experience of seeing how people are dealt with is pretty shocking in many ways. So yeah, and I think the other level it kind of works at is, you know, in one sense, yeah, you can have kind of like a council team like acknowledging trauma, but if you've got a case like Brentwood where like 90% of people have been, you know, basically failed systematically every, you know, across a 6-month period, most of those, many of the people being failed will be traumatized people who are in priority needs, who have been told they're not, or kind of, you know, haven't even kind of hit the Section 108 threshold or anything. So and again,
And
mention it. I mean, I'm sorry, I'm
so
going to have to take issue with the guy saying this. DAHA accreditation is great. You go and speak to professionals who know what they're talking about how it works. It's not. Is again, it's just talk. It's just talk in a lot of cases. So and also with DAHA, you get the accreditation itself is good, but then there's no monitoring. So basically, you know, council meets the standard, and then it just falls back. I've seen that with a local council not too far from us. So yeah, I think it's really important here. This is the reason I'm getting a little bit animated about this. Is that you know, my experience of accompanying and kind of being involved in many homeless application processes is that there is an element of gaslighting going on. There is an element of just kind of you know, kind of willfully ignoring relevant medical information around trauma. So I have not seen it done well with the council. Now, yes, I will generally pick up on cases which aren't done well, but I've seen so many shocking ones. So as I say, maybe Stockport's doing something amazing. I'd be interested to speak to people in Stockport on the ground who are actually going to the housing option service. So yeah, yeah. So that's my piece anyway.
No, it can go. But even when people go for the simple first initial advice, often they're so traumatized by that initial appointment, they're like, oh, I can't go back there. So they face homelessness from the point of they were basically shunned and spoken to really badly at the first appointment. So it's like
Yeah,
the council is there to help people in their borough, to look after people in their borough. That's their job. That's what they're for.
yeah. So
And the number
sorry.
of people we speak to that are just traumatized from even going in the building, the letters they receive and things like that. It's just,
Yeah.
it's terrible.
So Shannon, I've seen you want to come in, but I just want to say this as well. So one of the kind of straightforward things I say about this is that, does your council conduct interviews in an open plan customer service centre? If the answer is yes, it is not in any way trauma informed, because you're expecting people to share very sensitive stuff. It's unlawful as well from a data breach point of view. But I say to any council, you know, I mean, yeah, literally the first thing before you've even spoke to a housing officer, where are you actually speaking to your housing officer? How are you sharing that information? Can someone else hear you? In Bedford, we've kind of got this recurring issue because they're now not budging on kind of housing of doing it in private interview rooms. But the kind of idea of, you know, the trauma informed stuff you get kind of a lot of charity spouting when you see what's going on the ground. It's not people's experiences of how it works. Sorry, Shannon.
no, I'm just gonna say one thing because I know we're overrunning, and I think it's a shame we don't have more time for this conversation because it is interesting. Um, and this is like what all everything we're saying is not personal attacks, but there is crap practice, but great outcomes. I would perhaps reflect on who those great outcomes are for and what you're measuring as good outcomes. Because I think so often, because there's no like co-production, there's no involvement with the person going through this process, even though it's a legal process, which is mad, because there's no involvement with that person, actually what the council is saying is a great outcome is a horrible outcome for that person. And Paris is right, like my homeless interview, homeless application interview was 5 years ago now. And still, I go past Bedford Borough Council building, and my little heart goes, and I'm like, oh, and I get a little letter with their logo on, and I'm like, what have I done wrong now? What am I not going to be believed about now? And it really stays with you. And it's great if there is some good work going out, and I wish more councils would do that, but I don't think they're going to do that until they're held to account. And that's what I'm going to say, because I know we're running late, and yeah, there's not enough time to have this conversation properly, is there, Drew? So
we should, no, it'd be good to find a way to return. I mean, if Jeff, if you want to just kind of reach out, probably best ways on the Facebook page. If you'd message the Facebook page at Homelessness Best Practice, because I guess it'd be good to hear more. But yeah, as you can tell, we're kind of like, so as I say, I've literally worked with hundreds of people who I would say most of whom are traumatized. There are, even when you've got housing officers who are actually decent people, the way the process works by definition is going to be traumatizing. So yeah. All right, guys. Well, hopefully there's some interesting stuff there for everyone. Hopefully we've answered some questions reasonably well. Be back next week, but next Thursday on this channel. I'm guessing Will won't. I think Will's on his travels this weekend, so no Monday thing from him. I know he's kind of
I think he's coming back the 28th.
Okay, so okay, so
we'll
so no next week, but yeah.
To the floor.
Couple of notices as well from me. So I'm about to put up a new training date in July. So we've got about half the places filled in the June one. I've not even advertised it yet. So as in, I'm not boosted it yet. So I'll put a date up in, I think it's going to be 11th of July if you want to keep an eye out for that. As always, keep the questions coming. Hope this has been useful. And for those people who like kind of wait to the live stream to ask you questions, you're probably better off asking it during the week on a comment on the video, anonymized, and you'll guarantee getting kind of your question answered first. And there's no character limit, which is probably quite helpful. Cool, nice one. Cheers, Karis. Cheers, Shannon. Thanks for all your comments tonight, guys. Any questions? It's cool. Hopefully see you next Thursday, and hope you have a bit of time with a bit of headspace over Easter.